everyone. This is Ted Murmagos, and I am the Division Director here at the Division of Child Support Services in the state of Delaware. And this is the September 2025 Child Support Connection. We could not have the event last week because of the Labor Day holiday, so we planned on doing it today. And I certainly hope that individuals choose to join us so that we can talk a little bit about some of the things that are going on with the Division of Child Support Services. And as I always do, I'm going to start off by going through our division's mission statement. And then I'll talk about a few rules that we put into effect so that people understand how to share information on our Facebook page. So I'll go ahead and get started. It's our mission here at the Delaware Division of Child Support Services to deliver quality customer support while partnering with parents to improve the lives of their children and their families. This is achieved through obtaining accurate child support orders to meet the financial, medical, and emotional needs to promote family self-sufficiency and the best outcomes for children. So I'm really proud of that mission statement. And it's something that we here at Child Support talk to all of our employees about, and hopefully making sure that they understand really what the goal is here, what the end goal is in trying to make sure that we are working closely with both parents as well as the Department of Justice, who is our attorneys, and then the family court to get those child support orders put in place. And when we talk about child support orders, we talk about documents that are put in place by the family court here in the state of Delaware. We are a judicial state, so the family court really controls the court orders as it relates to child support. But we don't want to see, and this may be a little surprising to some, but especially custodial parents, we don't want to see non-custodial parents placed under child support obligations that they can't afford. Because we see it all the time. If these obligations get too big, non-custodial parents struggle in making those child support obligations. So when we talk about obtaining accurate child support orders to meet the financial, medical, and emotional needs, it's really all about making sure the court puts in place child support obligations that can be afforded by non-custodial parents, and those payments get sent to us here at Child Support, and we forward them on, to custodial parents. So, we see it all the time where a non-custodial parent who is placed under an order they can't afford stops paying. Those arrears balances accrue at a huge, fast rate. They wind up throwing up their arms and saying, I'm never going to get out from underneath all of this debt. And they stop paying. And we really don't want to see non-custodial parents fall into that trap. So we work very closely with the court and the Department of Justice to make sure we're asking for child support obligations that are affordable to non-custodial parents. So that's our mission statement. And the other thing I always like to start off these child support connections by talking about is we have to be very careful what we're putting in the comment sections, and I'll mention this throughout the hour. We don't want to release any confidential, personal information about the other parent, the children, We don't want to see names or dates of birth, especially we don't want to see social security numbers or anything like that. So if you do put a comment in the comment section, we ask that you don't provide any personal identifiable information in the comment section. And then as it relates to the comments, like I say all the time, as I'm going over some things we're working on here at Child Support, if I see that there's a comment placed in the comment, I'll stop what I'm talking about and we'll go ahead and address any comments. And I see that there may be a new comment. Yeah. So I will stop what I'm talking about and I'll go ahead and answer Ms. Happy's question. So the question is, I asked for a modification for several years, and my one last year is still sitting pending with the court with no scheduled date. Can you tell me why others have been scheduled the week they asked for it, but mine just sits? So yeah, this is problematic, and there could be several reasons. Well, it could be a couple of reasons for the delay. And the first thing I want to say is this. If you've been waiting that long, several years, to have your modification petition heard, I'm hoping that you've reached out to if you're a client of ours here at Child Support, that you've reached out to us here and given our your child support specialist, your worker, an opportunity to reach out to the family court to find out what the delay is in scheduling it. It doesn't even sound as though the scheduling process has occurred yet. And if that's the case and it's been sitting for several years, there's an issue that we need to investigate and get back to you with. So here's some suggestions. One, and you're probably going to say maybe you've done some of these already, but it's good for me to put it out there for other people too. One, call Child Support. Call us at 302-577-7171. Speak to a worker in our customer service unit. They can actually access the family court's computer systems to find out what the status of this modification petition may be. And if there's a situation, obviously we'll convey what we found out back to you, and then we'll try to get them to move that petition towards being scheduled and getting that court hearing on the book so that you can go back into court and have that modification petition resolved. I have and do not get a reason why and no help to push it through. Okay, so yeah, so that's the thing. I would reach out to us first, but it sounds like you've already done that. So one of the other things that I like to do here at these Child Support Connections is, if you want to send us a DM or a personal message through Facebook, I will go ahead and personally look that information through the Facebook page. I'll go find that comment, the personal message. Please include, though, your case number. If the case here at Child Support is under a different name for you, put that in there, and then phone number, your case number, and your name if it's different than what you're showing us here. And I'll go ahead and get the worker to look into it and find out what's going on and get that case moving. And I just got something that happens a lot of time, Ms. Happy, here is I do have a employee of mine also tuning in, and she's going to try to look your case up. Don't put any personal information in the chat. If we can't find you, send us that message and we'll go ahead and we'll get in contact you after the Child Support Connection is over. But I wanted to let you know I do have a worker who is researching this right now for me. So I see there's another question here. What is the process to modify a court order? Okay, thank you very much for this question. So a couple things have to happen. So there are things that will, in order to modify a previous court order, if the court order is over 2.5 years old, then the courts do like to see the previous court order and have it considered for a modification petition or having a new order created, because they want to make sure that, as I was mentioning earlier, that all parties are paying what is the equivalent amount of child support based on their income. So, number one, if the previous court order is over 2.5 years old, you should contact, if you're a client of ours, you should contact your child support specialist. I gave the number out, I'll give it to you again. It's 302-577-7171. And there's some stuff that has to happen. The worker will send you a letter for you to sign and return to us, indicating that you want us to pursue a modification. Now, the second thing that could trigger a petition being filed for a modification is if either party has a substantial change in their financial circumstances. And notice I said either party. So if, for instance, the non-custodial parent loses their job or gets demoted or goes to a different job and is not making as much as when that court order was created, that person can file for a modification decrease. Similarly, if the non-custodial parent is making more, gets a promotion, gets a new job, making more money, we could file on behalf of our client a modification petition with the family court. Normally what happens, there's a little work we do internally before we go ahead and hit that button and generate that petition. And we go and we run a child support calculation, just like the court would do. That you could actually go to the family court's website, and you can actually click a link that will let you plug in your numbers and plug in the other party's numbers based on the best of your ability or best of your knowledge, and you can kind of get an idea of what that new obligation is going to be. But if there's a change in that financial circumstances, either up or down by 10%, it could then go ahead and allow us here to generate a petition for a modification increase. Or it could allow the non-custodial parent to say, I want a decrease, and they go file that modification decrease on their own. So just to kind of regroup a little bit here. One is if the order is over 2.5 years old, that could trigger a modification being filed. Or two, either parent has a change in their financial circumstances, and most court orders that are issued in the state of Delaware say that the parents are to be providing each other with financial information. And that information can be used, if you get the other party's information, you could go to the family court's website and see, is that increase or is that decrease a 10% change? And if so, you may, if it's under 2.5 years, you may be due for a modification. And again, the custodial parent, if we're going to file something on their behalf, we would send them a letter and they would agree to allow us to seek that modification. So I hope I was able to answer your question. I know there was a lot there, but really the key is, and I'll just mention it one last time, the key is a financial change in circumstances, up or down by 10%. Of course, if it goes down by 10%, we would not file for a modification petition unless that court order is over 2.5 years old. And that's the second reason. But our employees, our child support specialist, can generate a modification petition on your behalf. if you are a client of ours here at Child Support. The other thing I would mention too is if you're not a client of ours, because I know people are viewing this video after the fact, if you are not a client of ours, you can always get an attorney to file for you a modification petition. It's going to be a little bit more expensive than rather if we did it. Or you can actually go into family court yourself. Both parents can have that and do that if they want to. And they can go and speak to someone who works in the resource center. And that person, you would tell them, hey, I need the paperwork to file a modification. And they would give it to you and they'd help you fill it out. They would provide you guidance on that. So, so I hope that was helpful as it relates to modification. Two great questions that are going to be very beneficial to anyone viewing this video after the fact. And then I'm going back to some of the original stuff I was talking about. And I mention this I think every month also, is I always am encouraging people, if you're a custodial parent, encourage the non-custodial parent to tune in here and ask a question, or to go into our Facebook page and friend us as a Facebook friend, and then go to our videos and watch the different child support connections that I've done over the years. There's a ton of valuable information that I think would help a non-custodial parent, and I'm always talking about the child support process here in the state of Delaware is not always easy. It's not always easy. It can be complicated. It can, so sometimes I think both parents need help with maneuvering through that process, understanding the child support process, the do's and the don'ts, what they can do, what they can't do. And we certainly here at Child Support are happy to answer any questions we can about the child support process. One of the things I don't really talk a lot about, but I should, is the accounting process. Because we not only process child support cases to get those cases within the family court, to help people either establish a court order, modify a court order, terminate a court order when the child has emancipated. But there's a whole other part of the child support program here. And part of that is the accounting functions that take place. So every court order that comes from the family court first has to be logged into our child support system, and then has to be created in a way to be able to accept child support payments and to keep an accurate log of every payment that came in the door from the payer, and that goes out to the custodial parent, also called the payee, keeping an accounting record of every payment to make sure that we're giving credit to the non-custodial parent for every payment that they've made. There is what we call our state disbursement unit who is responsible for the logging of those payments. Now, we get I think it's somewhere around 61 or 62% of our payments electronically, which is awesome. That's that helps kind of reduce the ability for someone to make a accounting error when they're typing in the payment amounts. But we have a responsibility here at Child Support to make sure all payments are accounted for. But when you throw in another state and payments that come from another state, or payments that are made directly to another state and bypass our office, there's a whole bunch of communication that goes on between our two state agencies to make sure the non-custodial parent is being given credit for a payment that maybe bypassed the state of Delaware and went directly to the state of Maryland or something along those lines. So there is an accounting unit, a state disbursement unit, that's really responsible for all of that payment logging that goes on and making sure we are giving credit to those individuals who are required to pay that child support obligation. That's why it's so important, just like a bank account. And this is a message for both custodial and non-custodial parents. You have to ask for an accounting, an account statement every once in a while. Make sure you're being given credit for every payment that an employer maybe sent to us, or that another state agency sent to us. You want to make sure that we are giving credit. You are giving credit for all of those payments. So it is extremely important for both parents to ask for an account statement. It's as simple as us printing it and mailing it to you. This is a perfect opportunity for me to talk about the child support customer website that can be found at www.my.delaware.gov. my.delaware.gov. And once you're logged in there, you would be able to pull down the child support portal. I always call it the website, child support customer website. And you would have to create a separate username and password. But once that's done, you can have access to your child support case. You can print those account statements from home. Don't even need to call us or come in or wait on hold or any of that stuff. Through the my.delaware.gov website. And then through the child support customer website / portal. Create another username and password and you got it. You can print the stuff at home. There's so many different things you can do through that customer website. So I'm always encouraging people to go there. And then when you need an account statement, you got it right at your fingertips. So every year around this time, I always mention to folks, we're gearing up for a legislative session that's going to start in January. So, I know that, like I mentioned already, I know people view these videos later. And you may not be viewing it right now as we're doing it live, but I'm always open here at Child Support to hear ideas about potential legislative changes. If you're a non-custodial parent and you have an idea about how we can, make things a little bit easier for a non-custodial parent, that's going to help them get back on track or help them continue to make those regular payments, I'm always open to hearing ideas on ways that we can improve the child support process. And if it requires a statutory change, I'm open to hearing it and talking to our cabinet secretary's office about making that legislative change. So I guess this is a call to folks that if you have a legislative idea that you think we should pursue, send us a message. Reach out to us via Facebook, and we'll go ahead and talk about it internally if we think it's a good idea. So if people are interested in doing that, I'm more than happy to advance their legislative thoughts. Also, I guess we should really take a little bit of time to just go over some other housekeeping issues. And okay, so I'm not sure if Miss Happy is still with us, but I did get some information, and she's correct. Her modification petition is still over at the court waiting to be scheduled for a hearing. And our folks have already reached out to the court to find out what's going on with that petition. So I'm glad she reached out through this. This is a perfect reason why we have these monthly child support connections. And I'm not sure if she's still with us, but we will reach out to her and let her know that we are asking the court to get this petition scheduled. And I will reach out to her separately, either through Facebook or another way. But so thank you for that information, my employee, who deserves the credit for handling that. So some other things, just to kind of, some light stuff here on a hopefully beginning of fall season. So as many folks know, here in Delaware we have 3 child support offices. One located in Newcastle County, and our address is 84A Christiana Road in Newark. Our second, how to get to our office. So I was our Newark office, Newcastle office, our Newcastle office. 84A Christiana Road in Newcastle. I don't know if I said Newark before, I didn't mean that. Newcastle, Delaware. So if you are looking for us, we are located at the Churchman's Corporate Center. And I always describe it as about a tenth of a mile, that would be west of Route 13. Large building on your right, it's the Churchman's Corporate Center. We're located there. In Kent County, we are at 905 South Governors Avenue. South Governors Avenue on the 2nd floor. I think the Department of Elections is below us on the 1st floor. And if you're looking for us in Dover or the Kent County office, we are about a quarter of a mile, maybe a little less, quarter of a mile, south of Kent General Hospital. And then in Sussex County, we are at 20105 Office Circle. And it's in the Georgetown Professional Park. And the best way for me to describe this to all of you is it is right across the street from the Walmart in Georgetown at the Georgetown Professional Park. So those are our 3 offices. Our hours are from 8 a.m. to 4:30 p.m. Monday through Friday. And we welcome people to certainly come to our office if they're having a child support situation or need more information about child support. More than happy to connect you with a child support specialist that can answer your questions. And I already mentioned our customer service telephone numbers. I'm going to do it again. 302-577-7171. And then you could always reach out to us through the customer website at 577-717, or the customer website. I don't throw me today. The customer website through my.delaware.gov. my.delaware.gov, drag over the child support customer portal, and you can have access to a whole bunch of stuff. You can communicate with your worker. You can check to see if a payment came in. I never understood why people would sit on hold when they can just email their worker and get an answer right away. So I'm encouraging people to go to the customer website. I thought I would take a few minutes. To talk about a couple of our enforcement tools, maybe a little bit more in depth. And thought I would start off by talking a little bit about whenever we take an enforcement action. So if we choose to intercept your taxes, suspend your driver's license, report you to the credit bureaus, whenever we want to take one of those actions, we always have to send the non-custodial parent a letter. So if you've moved, and we had a situation just in Dover last week, the individual moved, he was a truck driver, and we suspended his license. He came in really hot because we suspended his driver's license, but we sent him the letter. We gave him his due process rights, but he wasn't at that address anymore. Both parents are required to keep us up to date on their mailing addresses, so we can avoid situations where we go after someone using an enforcement tool and that person doesn't live there anymore and is not afforded their due process protections because they failed to keep us up to date. A lot of our enforcement tools, when we send out that notice of, hey, we're going to take this action, one of the things that is a result of that letter getting into the hands of the right person is that we can start a dialogue, we can start a conversation. If that truck driver had gotten the letter 3 months ago or 4 months ago when we sent it to him, he probably wouldn't have come in as mad at us as he was because we took the action that we said we were going to do. We said we're going to suspend your license, give us a call, reach out to us. He didn't do it because he didn't change his address. And because of that, his license got suspended. So it's so important for people to keep us up to date on their mailing changes. If you've moved, let us know. We really want to work with both parents as it relates to their child support. But we can't work with you if you don't keep us informed on where you're living, so we can mail you a letter when it's necessary. So it's always a conversation starter. And guess what? The sooner you get into us, hey, I got this letter, the better off you're going to be, because we want to work with people. We don't want to suspend a license if we don't have to. We don't want to report someone to the credit bureaus if we don't have to. But if that person doesn't reach out to us, we have no other choice but to move forward in order to encourage, through these enforcement tools, to get people to meet their child support obligations. So when we send out those notices, it's really about starting that conversation. Are you working? Can you tell us what you're doing for income? Are you looking for employment? Can we help you find employment? We actually have tools that will actually help someone who's ready to find employment. We can help them get that done. And the reason why I said they're ready to find employment, because we want serious people that are ready to put this issue of non-payment behind them and are really interested in making those regular payments to avoid some of the more stricter things that we can do or the court can do if a person doesn't follow the court order that they're currently under. So we do try to work with non-custodial parents. For instance, you want to get your license back, you have to make a lump sum payment for the payments that you've missed, and that was the reason why we sent you the letter. You did make a payment for 60 days, we sent you a letter. But the expectation is you're going to get that letter, you're going to make some payments, you're going to get back on track. We can help non-custodial parents get back on track with their child support obligation. So that's one of the other things I tell non-custodial parents. It's never too late, no matter how bad that arrears balance is. It's never too late to get on track. One of the other things too, and we really don't talk about this a lot because it's a little controversial. But sometimes I talk to non-custodial parents and I say, look, if you could start making regular, consistent child support payments, doesn't even have to be for the court-ordered amount in the beginning. Get yourself back on track, that kind of thing. Get a modification petition filed at family court. We talked about that earlier. But if you can start to make regular, consistent, every week, every 2 weeks, every month, you're making a regular, substantial payment, you're showing the custodial parent, you're proving to them, hopefully after a long period of time of making those regular payments, that you're, in their frame of mind that you're going to continue to make those regular payments consistently. Maybe they'll wipe off a little bit of it. Maybe they'll forgive a little bit of those arrears as a goodwill gesture to you for making those payments on a regular basis. I have no guarantee of that. They don't have to. Legally, they don't have to. But what better way to get some unity between both parents than just to make those court-ordered regular payments, or make what you can on a regular basis, and then get into court to file for that modification. But it's definitely going to look better in the eyes of the custodial parents. It's going to look better in the eyes of your children. So, just a little bit of advice. And we got a new question. So let me see here, Miss Edie. Welcome back. I had to close my bank account and open a new one. The online form states that it could take up to 14 days from when they receive it. What happens if a payment? What happens if I get a payment during that time, or is there a way I could expedite the process? So, you know what? This is a great question, and I really appreciate it because this is something I don't talk about a lot, and I should. So, thank you for that. So, let me get specifically to your question, and then I'm going to talk broadly about electronic payments to the Child Support Office. So, When we receive that new direct deposit application or the U.S. Bank issued Relia card application, but this is more for folks that sign up for direct deposit. What has to happen is once we get the application with a new, in your case, a new bank account's information on it, there is some things that actually take place behind the scenes to validate that that bank account is accurate, that it's assigned to, that you're the bank account person on there, and they basically validate, yes, it is this bank account and routing number are correct. It is for Tammy Edie, so there's a little back and forth that goes on between the computer systems, between us and the bank. It doesn't usually take the full 14 days, anywhere between 7 to 10 days for that process to be validated. And then any payments that come in would then be redirected to that new bank account. If you have not spoken to a child support specialist to let them know that this is a situation that's going on, you should do that. Just call us and let us know, hey, this bank account that we have on file is no longer valid. And something can be done, I believe, to stop any future payments from going to that old bank account. I would encourage you to very quickly and accurately, I'll throw that in there, to get that new direct deposit application into us so we can get that process started. Any payments that come into us in the window of updating the new bank account would be sent to you in a check form. So we would delete that old bank account, we'd put in the new bank account. Anything that comes in would go out to you in the form of a check. That is another reason why to have an act, this is not specifically for you, but just something I was just talking about. It's another valid reason why we need accurate mailing addresses for both parents in our system. So not only do we send notices out, but in your situation, we would maybe potentially be sending you a check. So we need to make sure, too, that we have your accurate mailing address in our system. But the reason for that, we say 14, but I think it's somewhere between 7 and 10, just to cover us. There is that validation process that's going on. So the sooner we get your application with a canceled check, the sooner we can go ahead and get it in our system and communicate to your bank that we want to send payments directly to them. So I'm hoping that I was able to answer your question. I really appreciate it, because I don't really talk about it a lot, about direct deposit and all the stuff that goes on behind the scenes. But that's a really good question. So I hope I was able to help you with that. So going back to some of the enforcement tools, our biggest the two biggest enforcement tools that we have. One is issuing wage withholdings, also known as orders of income withholding. We send out thousands of income withholdings a year, and employers, who are our biggest stakeholder in this child support process, maybe second most biggest stakeholder under custodial parents, but employers are very helpful to the child support process because they receive those orders of income withholding and they make a deduction from an individual's paycheck, and they then will send those payments to us here at Child Support. 76, maybe 75, 76% of all payments we get are from employers as a result of orders of income withholdings that have been sent by us to them. So we do get a lot of money through the orders of income withholding. The second biggest enforcement tool, and one of my coworkers or two of my coworkers are on, they can certainly dispute this if they would like to. But I think like the second biggest enforcement tool that we have is generating and filing contempt petitions with the family court. We generate a lot of contempt petitions for non-custodial parents who just are not paying their child support as ordered by the family court. So we do that a lot. And then third and fourth would be license suspension. And we do get a lot of phone calls and a lot of discussion happens around the license suspension process. In Delaware, we can suspend a driver's license, a business license, a professional license, or a hunting and fishing license here in the state of Delaware. And believe it or not, the hunting and fishing, that does generate a lot of conversations to our office. People want to be able to hunt, they want to be able to fish, but if they owe child support arrearages and have not made a payment in 30 to 60 days, we're going to go ahead and ask the Division of Wildlife here in Delaware to suspend those licenses. So we don't want to, we certainly don't want to make sure that doesn't happen. But so there is a lot of various enforcement tools, but being able to work with custodial parents is really the most important thing we can do. Is having that one-on-one engagement with custodial parents to help us enforce these child support cases. Oftentimes I'll read in some of the comments section, or I'll get an email from a custodial parent who says it's not my job to do blah, blah, blah. It's your job, child support, to make sure he pays. But in reality, custodial parents are our best partner in this process. They are our best way of getting information on non-custodial parents. So if you're a custodial parent and you get new information about the non-custodial parent, whether they moved or a new place of employment, you should always talk to us here at Child Support about what's going on in the non-custodial parent's life to keep us updated on their child support case. So I always talk to custodial parents and say, we have a lot of tools here, but you're really our best tool. You're really our best tool. KPS is being issued as a waste of time. It's not enforced. Thank you for the question, Jen. And to a certain extent, I agree with you. Let me just explain a little bit. A KPS is a civil bench warrant, and when an individual fails to show up to a court hearing or fails to get genetic testing done, the family court can issue a KPS, a civil bench warrant. And I do a lot of time talking to non-custodial parents and say to them, if you have a KPS, you should turn yourself into family court. And I always tell people, 9 times out of 10, they are not, hear me out, they are not going to incarcerate you. But they're going to cancel that bench warrant and they're going to reschedule you for a family court hearing. And let's talk a little bit. I see you've added something. But I always talk to them about, you can get that KPS canceled, you can make a lump sum payment and then go get the KPS canceled, but you're showing the court that you're going to show up to the next court hearing, and the courts will go ahead and schedule that hearing when you turn yourself in on a CAPIAS. So the other reality about a CAPIAS, while we're talking about it, and I'll stick around a little bit longer if I have to, the other thing about a CAPIAS is if an individual has a CAPIAS on them, we really would hope at child support that if they get pulled over for speeding or a traffic violation, or they're involved in another criminal, involved in a criminal activity, and they have a police engagement, we would really like the police to bring them into court, bring them into the family court on that family court CAPIAS. But we have a hard time convincing police, and some of it's for valid reasons. They don't want to be off the street. If they arrest somebody and have to bring them to family court, is there a way that the court could improve and reduce the amount of time where that law enforcement officer is, not in the court having to deal with that CAPIAS, but back out on the street? So we have very difficult times, I'll put it like that, getting police agencies to help us enforce those CAPIASs. But I'm always encouraging non-custodial parents to turn themselves in and bring some funds with them to make a payment, a lump sum payment. So when you say this was for non-payment, I'm almost wondering if it's more like a purge payment, or a purge payment is if you don't go to child support by such and such a date and make a payment, you're going to be incarcerated, right? And this works very well because nobody wants, especially if it's on a Friday. I can tell you our waiting rooms are very busy on Friday afternoons with people wanting to avoid being incarcerated, so they come to child support and make that payment. If that's that may be a situation that you're, and you should tell the custodial parent ahead of time. Yep. So that may be a situation you're dealing with, and if that's the case where the courts have said you're to make a payment by such and such a date or you're going to be incarcerated, and that date has come and gone, and the person has not met that obligation, they've not made that lump sum, we should really find out, we should know about that. And we should bring it to the court's attention through the Department of Justice that the person has failed to make those purge payments. And maybe that's how that civil bench warrant, that CAPIAS, got issued, for them to be, now in that situation, the non-custodial parent is in a heap of trouble. If the courts have said, you're to make a lump sum payment by such and such a date or you're going to be incarcerated, and that date has come and gone and no payment has been made, you're absolutely right. They could say to this person, that non-custodial parent, and in this case I would tell you, they could incarcerate. That's a situation where when that dude, that non-custodial parent does get picked up, they probably will incarcerate that person. And Jen, if you want to, one of my coworkers said that they would look at your case for you. So if you want to, I don't know if it's called personal message us or DM us, send us a message. She'll look into it. Make sure though, include your full name, Jen, and include and I say this to women, include your full name, how we would have it in our child support system. So if you're remarried or something along those lines, don't leave us if it's your case isn't under your married new name, don't give us that. Give us your whatever your name is in the child support case. And make sure, if your last name is Smith, Jen, put your date of birth in the message too, okay? Or so we can look you up, and your case number if you have it. And someone will get back to you to find out what's going on. Someone can get back to you. But in those situations where the court has said to someone you're to make a lump sum payment and they don't do it, they're really in a heap of trouble, because the court commissioners, they do not like it when a non-custodial parent has been ordered to make a lump sum or face incarceration and they don't do it. So it can be a very tricky situation for that non-custodial parent. So I see that we're getting close to the end. 12:30 is coming around rather quickly here. Really appreciate the questions. These were great. I was a little concerned in the beginning when there weren't a whole bunch of people waiting to send me questions, but I'm glad you did. And I just want to run through a couple things. One, we will be back next month, and I'm looking at my calendar, and it looks like it's October 6th for the next Child Support Connection. We hold them between 11:30 and 12:30 so people can tune in on your lunch break. Go out to your car and tune into the Facebook Live event. And our customer service unit telephone number, 302-577-7171. Check out my.delaware.gov, my.delaware.gov, and check out the Child Support customer website. Get access to that. You can have pieces of your child support case from home. You don't have to come to our office seeking an account statement or to speak to your worker. You can do it right through that customer website. And then, stay tuned. And really, this is the last thing. If you know non-custodial parents that would value from this Child Support Connection, send them to us. Send them to our Facebook page. Have them check out our previous videos. I'm going to start next month promoting our YouTube page. We really need to get folks to check out our YouTube page. We're going to start putting some of these videos over there so people can tune in and check out some of those videos from there and send us comments or questions through the YouTube channel. So thank you all very much. I really appreciate you tuning in. Thank you for the great questions. And I will see you next month. I'm just double checking it. Yeah, October 6th, which is Monday, October 6th. Thank you, and have a good rest of your month, and I'll see you in October.